Good afternoon. Let us come to order and go on the record. I am Commissioner Karen M. Kimmerite, presiding commissioner for this hearing. And with me this afternoon are Chair Charlotte Mitchell, Commissioners Tanola D. Brown Bland, Daniel G. Clodfelter, Kimberly W. Duffley, Jeffrey A. Hughes, and Floyd B. McKissick Jr. I now call for hearing docket number E-34 sub 54, which is the application of Appalachian State University doing business as New River Light and Power Company that I'll refer to going forward as either New River or the applicant for the adjustment of general base rates and charges applicable to electric service. And docket number E-34 sub 55, which is the petition of Appalachian State University doing business of New River Light and Power for an accounting order to defer certain capital costs and new tax expenses. On December 22nd, 2022, the applicant filed an application with the Commission pursuant to North Carolina General Statute sections 62-133 and 62-134 and Commission rules R15, R117, and R827, seeking authority to increase its rates for electric service in its service territory in Watauga County, North Carolina. And I'll refer to that going forward as the application for general rate case. On January 11, 2023, the Commission issued an order establishing a general rate case and suspending rates. On January 18, 2023, the applicant filed a motion to consolidate dockets E-34 subs 54 and 55. On January 31st, 2023, the Commission issued an order granting the motion to consolidate the dockets. Appalachian Voices and Nancy LaPlaca petitioned to and have been allowed to intervene in this proceeding. On March 20, 2023, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring customer notice. On March 28, 2023, the applicant filed amended Exhibits B and C to the application, and the Commission issued an order requiring corrected customer notice and requiring amended application schedules to be filed. On April 10, 2023, the applicant filed updated costs and amended exhibits to the direct testimony of Randall E. Halley. On April 24, 2023, the applicant filed the affidavit of publication of customer notice. On May 2nd, 2023, the applicant filed amended exhibits A, B, and C, concurrent and proposed rate schedules, and the verified certificate of service of notice to customers. A public hearing for the purpose of receiving the testimony of public witnesses was held on May 23, 2023 in Boone, North Carolina. On June 6, 2023, the public staff and interveners Appalachian Voices and Nancy LaPlaca filed their direct testimony. On June 23, 2023, the applicant filed its rebuttal testimony. On July 5th, 2023, the applicant filed an agreement and stipulation of settlement between itself and the public staff. On July 6, 2023, the applicant and the public staff filed settlement testimony. And that brings us to this afternoon. Pursuant to the State Ethics Act, I remind all members of the Commission of their duty to avoid conflicts of interest and inquire if any commissioner has any known conflict of interest with regard to the matter coming before the Commission. Seeing none, please let the record reflect that no conflicts were identified. I now call for appearances of counsel, beginning with the applicant.
Good afternoon, Commissioners. My name is David Drews, representing New River Light and Power. And before my colleague introduces himself, I also like to note that in the audience, we have a summer associate, Timberly Sutherland, who's here to observe, and Appalachian State University's in-house counsel, Crawford Cleveland.
Good afternoon. My name is Gray Stiers, law firm of Fox Rothschild, also serving as co-counsel with Mr. Drews on behalf of the applicant, New River Light and Power.
Okay. Good afternoon, Mr. Drews and Mr. Stiers. Moving to the interveners, beginning with Appalachian Voices.
Good afternoon, Commissioners. Nick Jimenez with the Southern Environmental Law Center for Appalachian Voices.
Good afternoon, Menashe Maguire, co-counsel on behalf of Appalachian Voices.
Good afternoon, and Ms. LaPlaca.
Nancy LaPlaca, representing myself as a New River Light and Power customer.
Good afternoon.
Good afternoon, Presiding Commissioner Kimmerer and Commissioners. Tom Felling, along with Will Freeman and Zeke Screech, public staff on behalf of the using and consuming public.
Okay, good afternoon. And before we get started, do any of the parties have any preliminary matters that we need to address?
We would like to correct a typo that is in the agreement and stipulation of settlement that was filed on July 5th of this year. And we have conferred with the public staff on this. On page 4 of that stipulation, there is a paragraph 16 entitled Accounting Adjustments. And in the third line, it refers to a UBIT estimated amount of $364,646. That number is correct. 2 lines and 5 lines below that, the number is incorrect because there's a transposition of 2 digits where it says 346,646. That should be 364,646. And that's the only matter we have. Thank you.
Thank you. That correction is noted.
Commissioner Kimmerer?
And there should be a correction a couple lines down as well.
Thank you. Yes, we agree.
Commissioner Kimmerer, just for the record, I'd just like to note that New River's witness, David Jameson, the Vice Chancellor of Appalachian State, will be available tomorrow. To the extent that we compress some of the testimony by combining our witnesses, I don't think we'll be ending the hearing this afternoon, but Mr. Jameson will not be available till tomorrow morning, but he would be available first thing tomorrow morning.
Okay. Thank you, Mr. Sires. Are there any preliminary matters that need to be addressed from the interveners or from the public staff?
Commissioner Kimmerer, one preliminary matter from App Voices. For the record, Menashe Magruder on behalf of Appalachian Voices. Appalachian Voices would like to make a motion for leave to offer live supplemental testimony on the stipulation. If the commission would permit it at this time, I have some additional remarks regarding this motion.
Please go ahead with your additional remarks.
Okay. Thank you. So the agreement and stipulation of agreement between the public staff and New River, along with settlement testimony filed by the public staff in New River, was filed July 6th, as the commission knows. However, that's only 2 business days prior to the commencement of this hearing. By its own terms, the stipulation addresses all remaining issues of disagreement as between those 2 parties. App Voices believes there would be a benefit to hearing additional expert opinion and perspectives on the stipulation, given the comprehensiveness of the stipulation and the complexity of underlying issues. We would submit that live supplemental testimony would be an appropriate vehicle to address these concerns, given the stipulation was filed well after the intervener filing deadline. The scheduling order doesn't contemplate pre-filed testimony being submitted in response to the stipulation. And had App Voices moved to pre-file supplemental testimony, there's a possibility the hearing could have been pushed back. We're mindful, obviously, of the constraints on the commission schedule, so we didn't want to do that. We're also aware of the equities also at case in the proceeding. We're aware, obviously, several witnesses and parties have traveled today and didn't want to affect that. Moreover, if App Voices' motion were granted, we believe it would help put the parties on a more equal footing. New River and public staff have filed settlement testimony prepared by their expert witnesses, while App Voices experts have not been afforded the opportunity. And if the commission were to grant this motion, New River and the public staff could conduct cross regarding the live supplemental testimony and or conduct redirect if applicable. Indeed, actually, in the proposed witness list that was filed by the parties, New River and public staff mentioned that they intended to conduct cross and redirect on any issues that were left unclarified and or to just reaffirm the party's support of the stipulation. So again, we would request respectfully that we be given leave to file supplemental testimony on the stipulation. If it were granted, we would just seek to provide some, supplemental testimony regarding the cost of capital, I think net billing and cost of service study terms of the stipulation, along with some issues that we believe were left unaddressed by the stipulation, specifically energy efficiency and some capital financing issues. So.
And does New River have a response to this motion?
Yes. And this is the first we heard of this. I believe that the issues regarding net billing and related to standby charge, basic facility charge and all that were thoroughly vetted in the pre-filed testimony, and there is nothing new in the settlement about that. So it would not be appropriate to have supplemental testimony on those topics. Same goes for accounting adjustments, because that was not something that Appalachian Voices spoke to in their testimony. The only thing that their case has that was addressed in the settlement stipulation is cost of capital. And we just ask that first, any supplemental testimony that is allowed be limited to that topic. And second, that our witnesses have time to confer with counsel among themselves and provide any rebuttal to that supplemental testimony after, at least a short time to digest it. And in case my colleague has anything else, I'll check with him.
And so for Appalachian Voices motion for clarification, is your motion to have live supplemental testimony and in addition, written supplemental testimony, or simply live supplemental testimony?
Oh, thank you for that clarifying question. We're only asking for live supplemental testimony, and the reason why we're not pre-filing supplemental testimony again was for the reasons I sort of set forth. We didn't want that to impact the hearing date. I guess if I may respond to Council Drew's remarks.
Please go ahead.
I guess what I would say in response to that is, again, the stipulation is sort of a comprehensive agreement. And while there are obviously some similarities with respect to what the parties testified to in their pre-filed testimony in the stipulation, again, I think the stipulation needs to be viewed as a whole. And while, again, there are some similarities between those issues, I think just comprehensively, it does create a different state of facts that exists now as opposed to when the parties pre-filed their testimony. And so I think we would disagree or dispute with the fact that there is enough similarity to sort of say that the parties can rest solely on the pre-filed testimony that was filed. Again, we have no objection, obviously, to App Voices or the public staff conducting cross-examination with respect to our witnesses. But again, for the purpose of clarification, we're not asking to pre-file any supplemental testimony. We're merely asking for the opportunity to have our experts be able to opine upon the stipulation as a global settlement of the remaining issues that were resolved as between the parties. And so would sort of resubmit that, again, it's a comprehensive settlement. To the extent that there are some similarities in the issues that were put in the pre-filed testimony, we would argue that viewed as a whole, it is a completely different set of facts and law that exists as it stands right now, as opposed to when the parties pre-filed testimony. So that's what I would say in response.
Okay, before I rule on this motion, does the public staff or Ms. LaPlaca have a response that you would like to provide?
No.
Without weighing into the dispute between council, the public staff has no general objection to that motion, so long as the testimony that's allowed be reasonable in scope and related to the scope of the settlement agreement.
So I'm going to allow Appalachian Voices motion. It will be live, not written supplemental testimony, and it will be limited to matters that are contained specifically in the settlement agreement. And New River will have an opportunity to cross-examine Appalachian Voices witnesses on this matter. So with that, are there any additional preliminary matters that the parties wish to address?
Just a clarifying question on the commission's ruling. When will this live testimony be provided? Will it be provided at the same time that the witnesses are called to introduce their pre-filed response testimony is my question.
Yes, that is correct, and I'm going to talk about that. I'll address that matter in just a minute. Before I move on to that issue, are there any additional preliminary matters that need to be addressed?
None from the public staff.
Okay. So a matter that the commission would raise is that we have a new order of witnesses, and this relates, Mr. Stiers, to your question. My understanding is that there is no objection among any of the parties. So if there is an objection, please raise it at this time. But the order of witnesses are going to be first, Ms. LaPlaca. Second will be testimony from Appalachian Voices witnesses Hoyle and Barnes, and that will be their direct testimony. And then in addition, their supplemental testimony that's going to be related specifically to the settlement agreement. And then after Appalachian Voices witnesses, it will be public staff witnesses for direct testimony and settlement testimony. And then finally, New River witnesses for direct, rebuttal, and settlement testimony. Are there any objections to this change in the order of witnesses?
No objection.
No objection from the public staff.
Appalachian Voices?
No objection from Appalachian Voices.
Okay. And Ms. LaPlaca?
No objections.
Okay, with that, we're now ready to get started with the case, beginning with the applicant. Apologies. We are not going to be beginning with the applicant. We are going to begin the matter with Ms. LaPlaca. Ms. LaPlaca, do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. And please state your name and address for the record, please.
My name is Nancy LaPlaca. That's L-A, capital P as in Peter, L-A-C-A. And my address is 239 Wildwood Lane in Boone, North Carolina, 28607.
And Ms. LaPlaca, do you have any motions in regard to testimony that you would like to have entered into the record?
Yes, if you could please enter into the record my direct testimony and also my summary.
Seeing no objection, Ms. LaPlaca's direct testimony filed in this docket on June the 6th of 2023, consisting of 13 pages and one exhibit, will be copied into the record as if given orally from the stand. And the summary of her testimony will also be copied into the record as if given orally from the stand. Ms. LaPlaca is available for cross-examination, beginning with the public staff.
Commissioner Kimmerat, we do not have any questions for this witness. Thank you.
And then I see that New River has cross-examination from Ms. LaPlaca.
And I know I believe when we filed the witness list sequence and all, we asked that we be the last party to do cross of interveners. Of course, we'll do whatever you think is appropriate, but that was our request.
Mr. Drews, I see that Appalachian Voices has not reserved any cross-examination time, unless that has changed, but you have not stated that you have any cross-examination. So it would be New River's cross-examination.
We have no cross.
Okay. So no cross-examination from any of the parties. Are there any questions from the commission? Ms. LaPlaca, there are no questions from the commission, so I appreciate you coming for the hearing, and you may be excused.
Thank you.
Okay. Now we'll move on to Appalachian Voices witnesses.
Thank you, Commissioner Cameron. At this time, Appalachian Voices would like to call Jason Hoyle.
Good afternoon, Mr. Hoyle. Will you place your left hand on the Bible and raise your right hand? And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you.
Thank you, Commissioner Cameron. Mr. Hoyle, could you state your name, title, and business address for the record?
Sure. My name is Jason Hoyle. I'm the Principal Energy Policy Analyst at EQ Research. My business address is 1155 Kildare Farm Road, Cary, North Carolina.
Please briefly describe your roles and responsibilities at EQ Research.
EQ Research, I am the lead on our general rate case service product. As part of that job, I review or prepare summaries on rate cases filed by utilities across the country with 50,000 or more customers. And we also prepare regular updates on the progress of various rate cases to our clients. I'm also the lead on our service program for community choice aggregators in California, where I'm in charge of essentially preparing filings for integrated resource plans, renewable portfolio procurement plans, handling items such as resource adequacy, reliability, and other sort of consulting services in that regard. And I also work on various consulting projects for other clients.
Thank you. Mr. Hoyle, did you cause to be pre-filed in docket numbers E-34, sub 54, and sub 55 on June 6 direct testimony and 2 exhibits consisting of a combined total of 62 pages?
Yes.
Do you have any corrections you'd like to make to your testimony or exhibits on the stand?
No.
So if the questions put to you in your testimony were asked at the hearing today, your answers would be the same?
Yes.
Did you also cause to be pre-filed in those same 2 dockets on July 6 a summary of your testimony consisting of 4 pages?
Yes.
All right, thanks. So moving on to the stipulation, have you had the chance to review the agreement and stipulation of agreement between New River Light and Power and the public staff filed on July 6?
Yes.
Have you had the chance to review the settlement testimony of Randall Haley filed on behalf of New River in those same 2 dockets on July 6?
Yes.
Have you had the chance to review the settlement testimony of John R. Hinton and James McLaughlin, both of which were filed on behalf of the public staff on July 6?
Yes.
Please briefly describe the stipulation terms concerning cost of capital.
Stipulation terms regarding cost of capital are an overall rate of return of 6.15%, capital structure 50% equity, 50% debt, cost of debt of 3.23%, and a return on equity of 9.1%.
All right, please briefly describe the stipulation's treatment or addressing of energy efficiency and demand side management.
The stipulation does not address energy efficiency or demand side management.
What concerns do you have the stipulation's cost of capital provisions?
My concerns are partly that it's based on a hypothetical capital structure. It's not cost-based. It has, in my opinion, an unreasonably high return on equity.
Okay. What issues do you have with the stipulation's lack of discussion of energy efficiency and demand side management?
Well, I would say that is the issue, is the lack of discussion of energy efficiency and demand side management. These are matters that have come before the commission before in New River's prior rate case. The commission's order at that time, to me at least, indicated some interest in seeing some development of these types of programs. So far, that development has been minimal and perhaps would stop altogether. It's hard to say, but there is nothing in the stipulation that would require the continued pursuit of these sorts of programs.
Thank you. One moment. Thank you. So in light of these issues and concerns you've identified, what recommendations do you have for the commission regarding the stipulation?
Well, my first recommendation would be that the commission should reject the stipulation. That it should reject it because it lacks reference to energy efficiency, demand side management program development. I believe the rate of return, the return on equity, and the capital structure are improperly calculated, I suppose is a good enough word, in the stipulation.
Okay. Commissioner Camerite, I would move to have Mr. Hoyle's pre-filed direct testimony exhibits with the correct, well, actually no corrections made on the stand today, and his pre-filed testimony summary be entered into the record as though given orally from the stand, and have the exhibits attached to his pre-filed direct testimony identified as pre-marked. I would also move that Mr. Hoyle's live supplemental testimony that was given from the stand today be moved into the record.
Seeing no objection, Mr. Hoyle's direct testimony filed on June the 6th of 2023 consisting of 48 pages, will be copied into the record as if given orally from the stand. And the 2 exhibits attached to the direct testimony will be marked for identification purposes as pre-filed. And the live summary will be copied into the record as well.
Thank you. Witness Horrell is available for cross-examination and questions from the commission.
Public staff?
Good afternoon, Mr. Hoyle. Thank you, commissioners. My name is Will Freeman. I'm an attorney for the public staff. All right, if you're ready, I'd like to ask you a few questions. I'd like to start with the overall rate of return, which I think you just addressed in your live testimony and also addressed in your written testimony. And if you're ready, I'm ready to proceed.
Yes, I'm ready.
And I kind of noticed as I was reading over your testimony, you filed at the same time as the public staff. And I noticed a lot of things that you asked for were actually done. And of course, you couldn't have done that when you filed. But one of the complaints I think that you have is that New River should conduct a discounted cash flow analysis. Does that ring a bell for you?
Yes, I believe that is one of the recommendations.
And you're aware that the public staff did conduct such an analysis?
Yes, I am now.
Well,
Or I
Mr.
was after reviewing the.
Mr. Hinton's testimony is right there on the corner if you'd like to look at it. That's his testimony that we filed the same day that you filed, if that would help.
I've reviewed that, yeah.
Okay. And if you were to look at Mr. Hinton's testimony, I think that you'd say that his DCF results were between 8.64 and 9.20%. You might want to look at page 24, but I don't want to rush you.
That is what it says, yes.
And the settlement that we discussed has a 9.10 return on equity.
I believe that's correct.
I don't have a copy of the I do have a copy of the stipulation handy if you don't.
I did bring that.
Okay, if you look at page 4, paragraph 14.
Yes, 9.1% is what is in the stipulation.
So we have, we did conduct the DCF analysis that you were worried that the company hadn't conducted. And it yielded a result that contains within it the settlement number. Is that correct?
Within the DCF analysis that Mr. Hinton conducted, that was based on publicly traded companies
Okay.
and dividend growth rates, neither of which apply to New River.
Because it's a governmental entity.
Yes,
Does it make any sense to you that a governmental entity might have an opportunity cost even though it is a government entity?
that does make sense. And we did look into this. Appalachian State provides no cash into New River Light and Power. New River Light and Power's only sources of investment are debt capital and its retained earnings. So the extent to which Appalachian State incurs an opportunity cost in regards to New River is that the university allows New River to occupy some very small amount of its overall debt limit.
All right. Let's now talk about the cost of debt, if we can.
I'm yours to ask questions of.
Well, I'm not trying to browbeat you or make you, I want you to say as much as you want to say on this topic because it's your day. I think that you noted in your testimony that Appalachian State University's most recent debt was at 4.06%.
Which page is that?
I believe it's on page 16 of your testimony.
If I may, could you, if you have the line number, could you direct witness Horrell to that line number, if you could?
It's at line number 9 on the far right part of the sentence.
Yes, that is the, let's see, the interest rate on bonds to build a parking deck.
4.06%.
Right.
Okay. And in this case, the recommended cost of debt in the stipulation is 3.23%.
So the parking deck in New River are very different, shall we say them, operating divisions of Appalachian State. New River Light and Power, when debt is issued or obtained on its behalf, must repay that debt with its own revenues, as opposed to elsewhere. I cannot speak to the circumstance of the parking deck. But at Appalachian State's debt that it secured to finance a parking deck in 2022 is different than the debt that it has secured to finance New River Light and Power.
Well, just big picture, we can say that the $20 million debt issuance was 80 basis points higher than agreed to in the settlement. 83, I guess.
Yes, roughly. Yeah.
Thank you. Okay. Let me talk a little bit about capital structure with you. And I think in your testimony, you recommended using the actual capital structure, 78% equity and 22% debt approximately. Does that ring a bell?
Yes, that's very close.
And you would agree with me that common equity is more expensive than debt.
Yes.
In this case, like far more, like more than twice as expensive as debt.
Well, New River Light and Power does not technically have common equity. It doesn't have shareholders. It doesn't have shares. Equity for a nonprofit, which Appalachian State is a 501c3 educational nonprofit, even though it is state controlled, generally builds up in what are retained earnings.
Well, I'm sorry, I didn't mean to cut you off.
No, that's the end of my statement.
Okay. I want to say two things. First, you're aware that New River pays taxes.
Yes, I was, as of reading the filings in this case.
Okay. Second, if we use a 78% equity and 22% debt, by reducing the equity and increasing the debt capital structure, hypothetical for rate making purposes, don't we save ratepayers money?
That could possibly be the case. You also obfuscate what's actually happening. The cost of debt is an actual cost, right? And that is a fundamental rate making principle. So the rate should be made on the basis of cost. And my personal opinion here, as in my testimony, is that New River Light and Power should receive the cost of its debt, not the cost of its debt plus some additional hypothetical portion of its capital, but the actual cost of its debt, not more than the cost of its debt, because that would provide sort of, let's call them hidden returns. They're not really hidden, but they would not necessarily show up on a simple chart showing the capital structure and the return on equity and the cost of debt. And as we've seen, New River Light and Power in Appalachian State have a much more complex process to obtain debt. So compared to, say, a utility or profit utility, perhaps with a publicly traded holding company parent, who might can issue bonds or refinance bonds fairly easily. New River Light and Power has a long, thorough process that could even potentially involve the Board of Governors for reviewing debt. So their likelihood that their cost of debt might change is fairly low.
Okay. Thank you for your answers. I'd like to just say your recommended overall rate of return was 5.39%. Correct. And
Yes, that's correct.
okay. And the company 7.007 or so percent.
New River,
Over New River's application, 7.007.
yes.
And the settlement, which I think you have in front of you, but I have one here, is 6.165%, which is in the middle, but lower towards the ratepayers' favor of those two ranges. Is that right?
I mean, I haven't calculated the average of 5.39 and 7.007.
I was eyeballing it, but it's like,
You know,
70 basis points above yours and 80 below, right?
something around there. Yeah, it's certainly in between the two.
Okay. And this is lower than the commission-approved rate of return from the 2017 case.
I believe so.
That was 6.525%, and this is 6.165%. Does that sound right to you? The order's right there on the corner of that desk if you'd like to look, but I'll represent to you that's what it says.
Pull the entire plat over here. Okay. If your representation is correct, I will.
And
accept that.
a lower rate of return, all else being equal, results in ratepayer savings. All else being equal, right? If you change nothing but the rate of return, ratepayers bills go
Ratepayers
down.
would save money, yes.
Okay. And the revenue impact, we know of this decrease from the utilities request is $315,000 in favor of ratepayers. And that is Finch Settlement Exhibit 1, Schedule 1, which is also right there in front of you if you'd like to look.
Do you have a page?
Schedule, if you look at Exhibit 1, Schedule 1, kind of in the, you keep going, you're close.
Yes, but this does not appear to be an all things equal type of number. Right? There does appear there are accounting adjustments from the public staff, which certainly goes beyond my testimony.
I did not mean to conflate two concepts. I had sort of finished one topic, which is all things being equal, a lower ROR is good for ratepayers, and then move on to a second topic to monetize, in this case, unrelated to that question, the savings to ratepayers by this lower rate of return. That was, so that second topic, would you agree with me that reducing the company's requested rate of return to the amount in the settlement agreement results in a ratepayer savings of $315,145?
Yes, that's what it says.
Okay. If you'll give me 1 minute, please. Thank you. Thank you. I don't have any more questions.
I have some questions this afternoon. Mr. Hurl, my name is Grace Stiers, counsel on behalf of New River Light and Power. So if I read your testimony correctly, your recommendation is that the commission should approve a capital structure of New River of 70% equity and 22% long-term debt. Is that correct?
Could you give me a page reference?
Well, I was asking about your
I have a lot of
recommendation
pages.
for your page 30, line 19 and 20.
Yes, 78.3% equity and 21.7% long-term debt.
And is the return on equity, the equity portion of that, 6.25%, correct?
That's correct.
Okay. And that 6.25%, the starting place for your calculations was a 5% municipal bond rating. Is that correct?
That's correct.
Okay. And you were relying upon what you said, recent municipal bond data showing that 5% rate for municipal bonds. Is that correct?
Yes, specifically the A-rated municipal,
Okay.
or actually the B-rated municipal bonds, the
And
level below the credit rating of Appalachian State.
Now, municipal bonds are a form of debt, are they not?
They are.
Okay. So you're recommending that the equity component of New River is financing be established based upon, calculated upon a debt rate, cost of debt for municipal bonds, correct?
Yes, that's correct.
Okay. But you would agree that even the debt portion of New River Light and Power is not technically a municipal debt, is it not? let me rephrase that. New River's debt is not municipal debt, is it not?
New River secures installment loans from a bank, and those loans do not function in a way similar to bonds. In fact, they require the repayment of principal almost from day one in most cases. This causes a number of issues with cash flow because the term of these bonds is far shorter than, or the term of these loans is far shorter than the depreciable life of the property that they are financing.
So the question is, no, New River Light and Power's debt's not the same as municipal debt.
New River Light and Power's debt,
Is not municipal
well,
debt.
Appalachian State University's debt is tax-free in the same way that municipal debt is. As to whether debt funding of New River Light and Power has a tax advantage on an equivalent basis to Appalachian State's, given the new tax status, I would say that I am not an accountant and I would recommend they speak with a certified accounting professional.
Okay, my question is not an accounting question, it's a finance question. Simple question. The debt that New River Light and Power had would not be considered municipal debt. Yes or no?
No, it'd be similar to state debt.
Right. Thank you. So the municipal bond data that you reference for your 5% on page 29, actually shown in a chart on page 17, I believe, if I'm not mistaken, of your testimony. Is that the type of municipal bond data that you are referring to in your setting a 5% starting point for your calculation?
Yes.
Okay, I was actually looking at the source material, even though that chart's not cited. I was actually able to find that source material. Those municipal bonds that were shown on your chart on page 17, those were general obligation. Municipal debt's a general obligation bond, is it not? Are you familiar with the concept general obligation bonds?
Somewhat.
So municipal debt is a general obligation bond, is it not?
Perhaps.
The general obligation bonds are backed by the full faith and credit of the issuer, correct? That's kind of the definition of a general obligation bond.
Right. That's exactly how Appalachian State University's bonds are.
Okay, so are you familiar with the concept full faith and credit for general obligation bonds?
I have not reviewed it for this particular testimony, no.
Subject to check. Full faith and credit general obligation bonds are backed by the taxing authority of municipality. Assuming that's correct, is it your understanding that Appalachian State has taxing authority?
Appalachian State's bonds are backed by the state of North Carolina, is my understanding. As a division of the state of North Carolina's university system.
But Appalachian State itself is not a taxing authority.
Not that I'm aware of.
Okay. So there is no full faith and credit of a taxing authority to tax its residents to support general obligation bonds like there is for municipal debt, is there?
I really can't answer with those technical terms. As I mentioned, I did not review these technical terms. I don't recall seeing them in any of the other testimony.
It's your understanding that general obligation bonds typically would have a lower interest rate than a revenue bond because it is backed by the full faith and credit of the issuer?
Again, I would repeat my previous answer.
You recognize that municipal debt is tax-free debt. It's a non-taxable debt on municipal debt.
Yes,
And you have said that New River Light and Power is a taxable entity because it has to pay unrelated business income tax, correct?
New River Light and Power pays unrelated business income tax as an operating division of Appalachian State. But I don't know that I would call it a taxable entity. It's not technically a separate entity, except for purposes like ours today. It is a part of Appalachian State, and Appalachian State is a nonprofit, right?
But you understand that
Commissioner Cameron, I would object this line of questioning. It's asked and answered, and also just pretty cumulative. I think the line of questioning, I mean, I think from what witness Harlow said, I mean, obviously he's opined upon sort of what the bonds are in question and whether or not they can be taxed. I feel like he's answered the question already.
I'll be glad to move on. I was exploring the basis of the 5%, and now I'd like to move on, if I may.
Then I will go ahead and sustain the objection.
Mr. Roy, then based upon that 5% number you drew from municipal tax data, then you added 1.25% to that, did you not?
I did.
Okay.
Because in order to obtain financing, this is required under the Hope decision of the Supreme Court. The rate should be set at a level that permits a utility to obtain financing.
So let me ask you about the
debt
basis. I'm sorry.
New River is allowed to obtain, or the only financing New River has available is debt. So in order to obtain financing, you have to provide enough cash flow to ensure that the lender's minimum discount service coverage ratio is met. So you cannot just say that having the cash flow or the return of 5% on a bond with an interest rate of 5%, that is not sufficient to obtain financing. There has to be additional cash flow, typically 25%. I use 25% in this case. That is the additional 1.25% above the bond rate.
So you understand that public debt is generally issued through an underwriting process, is it not?
Never issued public debt.
Okay. Are there, to your knowledge, financial advisors involved in the issuance of public debt, or do you know?
I would presume they're financial advisors.
Bond counsel often involved in the issuance of public debt?
I imagine there are a large number of people and titles involved in the issuance of public debt.
In coming up with your 1.25% and your overall 6.25% return on equity, did you talk with or consult with any financial advisors coming up with that number?
No,
Any bond counsel?
no,
Any underwriters?
no.
Public debt's generally purchased by institutional investors, such as pension funds, insurance companies, or exchange-traded funds. Have you talked with any institutional investors about their rate of return expectations for public debt?
No.
And if I ask you the same questions about risk analysis of university-owned utility systems, you haven't talked to anyone regarding how the market would analyze risk for public-owned utility debt, risk factors for public-owned utility systems, have you?
New River Light and Power is not a publicly owned utility, but no, I did not ask about publicly owned utility debt.
Now, you did cite on page 29, a footnote 54, that you did look at a Moody's investment municipal utility revenue bond methodology. And I'd like to hand that out, if I may, as an exhibit. And
So Mr. Stiers, let's first mark it for identification purposes, and we'll mark it as New River Cross-Examination FOIL Direct Exhibit 1.
or response exhibit 1, yeah, or direct exhibit 1.
Direct Exhibit 1.
Okay, thank you. So is this the report that you,
Could you you mentioned there was a citation somewhere?
bottom of page 29, footnote 54. Is this the report that you have cited in your footnote on the bottom of page 54?
Yes, in regards to the 1.25% above the base level of 5%.
And You actually pinpoint cite pages 8 and 9. So I'll direct you to page 8 and 9. So is there anything on page 8 and 9 that talks about kind of a 1.25% increase over your municipal base rate calculation to come up with your presumed return on equity?
So the 1.25% is not a random number. That is 25% above the 5% base level. That is the additional cash flow above what is required to service the 5% debt that a lender would require. You can see Exhibit 3 under the financial strength, debt service coverage. These are debt service coverage ratios for borrowers with different credit ratings.
So this is
1.25%. That's a 1.25 under column BAA. That is a credit rating below the level of Appalachian State's credit rating, which I also believe accounts for some of the additional risk and financial market uncertainty to use the requirements for the credit rating level below where Appalachian State actually is. That applies both to the 5% and the 1.25.
in this utility revenue debt methodology. There's a number of factors and sub-factors that are listed starting on page all the way back to 5. And that financial strength calculation on page 8 is one of numerous factors that this report lists, is it not?
Do you direct them to, I think you said starting at page 5? Are
Well,
there
I'm
specific-
just asking about the report. He's cited it. I'm just saying there's a numerous factors starting as early as page 5 that's covered by this report. And I'm just asking him, would he agree that there were various factors and sub-factors listed in utility revenue debt methodology, such as asset condition, service area wealth, system size, financial strength, annual debt service, et cetera. You would agree those are all factors listed in this report?
Those are all factors listed in the report.
Okay. In your testimony, did you cite any of these other factors in determining what you believe to be a rate on equity other than just the debt service ratio?
No, I did not. The financial strength, which debt service ratio is a part, is supposed to be the largest single factor. And it is also a very commonly applied metric for lenders in the sense that they will not lend money to someone that does not have the cash flow to pay the interest on their debt, as well as a bit of an extra margin in case, well, for whatever reason, cash flows at the company might decline for a short period of time.
Is there anywhere in this entire 24-page report in which there's any reference to equity or return on equity?
I couldn't say without reading the report directly or having a digital copy to search.
Okay, so let me help you understood that your answer. Let me subject check. Let me confirm that I have done a search, and the only place where I could find the word equity is on the last page, on page 24. And it's highlighted there towards the bottom in yellow. And if I'm reading it correctly, would you confirm that this report states that Moody's credit rating is an opinion as to the creditworthiness of a debt obligation of the issuer, not on the equity securities of the issuer or any form of security that is available to retail investors? Is that what that sentence reads?
That's what that sentence reads.
All right, so I think you've already discussed with public staff about the DCF analysis that you submit that New River should have performed. Did you yourself submit a DCF analysis as part of your report of this case?
I did not.
Did you undertake yourself any DCF analysis of New River Light and Power?
I have not.
Have you done a DCF analysis for any utility in your career?
Yes.
Okay. Have you testified to that analysis?
No.
So having done a DCF analysis, you're aware that the analysis involves numerous inputs, does it not?
It does.
Okay. And depending upon those inputs, the output of a DCF can vary widely, can it not?
That's true.
Okay. So when you made a recommendation of some type of compliance filing on a DCF analysis, you acknowledge that the DCF analysis output can depend upon the inputs that are made in doing that analysis.
Could you direct me to what you're referring to, please?
I don't have it right here in front of me, but is it your testimony that there should be a DCF analysis that's presented? Oh, page 46, lines 17 and 18. Make the recommendation that the New River should submit a compliance filing following completion of DCF analysis. Is that your recommendation?
That is, and the compliance filing should reflect or should include the DCF analysis and reflect the recalculated rate of return and capital structure.
But
So in the prior recommendation, I also recommended that New River develop a comprehensive financing strategy. Part of the reason for this is, well, I believe New River should conduct a discounted cash flow analysis. I do not believe that analysis should depend upon growth rates of dividend payments. New River Light and Power does not have a dividend payment like a for-profit company or a division of a for-profit publicly traded company. The closest you could get, I'm not going to concede that any for-profit company is technically a comparable that would be appropriate on a risk basis use in such an analysis. But if we were to go down that route, I understand that is the way things are commonly done. The appropriate growth metric to use would be one that New River actually has that can be compared, which would be a growth metric based on retained earnings.
But you've agreed with me that the output of the DCF analysis can vary widely based upon the input assumptions that go into that analysis.
Yes.
Okay. I think you said in your introductory remarks that you provide a rate case service for utilities over 50,000 customers. Did I understand that correctly?
Analysis of rate case filings.
Analysis of rate case filings for
Mostly, yeah.
utilities over 50,000 customers, correct?
Yes.
Do you know how many customers New River Light and Power has?
Not precisely, but I'll say somewhere maybe around the 15,000, 20,000 range.
So subject to check, New River has around 8,800 customers. So are you, do you know how much it would cost a small utility to have a consultant do a DCF analysis?
No.
Okay. So you wouldn't contest that the cost of that type of analysis by a consultant can well exceed $50,000. You'd have no basis to contest that.
I would have no basis to contest that.
Is there any commission order or rule that requires a DCF analysis to be filed by a utility in a rate case?
Objection to the extent that he's asking for a legal opinion from our expert.
Hey, just ask if he knows.
I'm not familiar with any such thing.
Upon the objection is overruled, and answer the question as to the best of your ability.
I'm not familiar with any such rule.
Are you aware that smaller utilities in North Carolina often file rate cases without a DCF analysis?
No, I'm not aware. I mostly work in electricity.
So you acknowledge, so shifting now to the EDSM. I just want to make sure I'm shifting gears here away from, and I just have a few questions in this arena. I'll refer you to page 42 of your testimony. you cite on pages 10 and 11 a number of variables that go into designing an EDSM program, do you not? Program design, incentive levels, expected savings, expected program costs, program evaluation, measurement and verification plans, et cetera.
You mean lines 10 and 11?
Lines 10 and 11, excuse me.
Those are program details that would be informative, yes.
So the success of a DSME program would depend upon a number of these variables. Would you not agree?
I would not describe it as the success. I mean, the success of a energy efficiency or demand side management program would really depend on the objectives of the program. Those objectives, these variables would perhaps inform the determination of whether a program's objectives were met, or inform the design of a program that was intended to meet those objectives.
But you were saying you were not able to evaluate possible programs because you haven't evaluated those variables, and you don't have a firm conclusion because you don't have answers to those variables.
We received a bulleted list of identified programs from New River Light and Power. That was the extent of the information, was essentially the name or a general one sentence or one clause description of the programs they had identified.
Without additional details such as these variables that you've identified yourself on lines 10 and 11, you don't know, the number of subscribers who would participate in any particular type of program, do you? That's the type of information you would need.
I don't know that anybody could know that for sure, but you could certainly develop information in the planning process that might provide some indication of interest by various stakeholders, including participants.
But that does require a planning process, does it not?
It does.
And that's kind of what you discussed on page 43, the very next page. And there you have listed various components of an DMS program plan, did you not?
I did.
Such as, again, establishing the goals, setting forth principles, characterizes and benchmark the residential sector, evaluates the variety of options, defines the evaluation, measurement, verification. Those are all parts of necessary parts of an EDMS plan that you've listed here. Would you agree?
Yes.
Okay. Now, you also stated that you acknowledge that New River is a small utility with very little experience in this area.
Yes. Their previous wholesale power contract and other related contracts essentially prevented the development of these types of programs.
So it does not have any internal staffing, to your knowledge, to perform this type of plan.
I'm not familiar with the capabilities of the internal staffing of New River.
Has Appalachia's recommended any expenses or costs be added to the revenue requirement in this case in order to cover DSME costs?
Not to my knowledge.
Okay. To the extent that grant funding would not be available, are you suggesting that New River design, propose, and implement such a program at its own expense?
Most utilities implement programs at expense. They also recover those costs. They also attempt to make sure that those programs do not cost more than the value that they add.
So you would agree that those would be reasonable costs for a utility to incur and recover from ratepayers?
It's possible that they could be reasonable costs.
Okay. Testifying today under oath, do you know how much it would cost New River Light and Power to implement your recommendations that you've stated on page 44? You made recommendations on page 44. Do you know how much those would cost New River?
Not specifically. I have not prepared a budget or an estimate, but I will point out that Appalachian State has a lot of departments that work in these types of areas. The economics department has familiarity with doing evaluations of these types of programs, designing certain types of programs. We have a building science department that is very familiar with energy efficiency and building codes, as well as, well, things beyond what I can even describe, the efficiency of certain appliances and building envelopes. That's where New River Light and Power has a large number of resources available that I believe would not only support the educational mission of the university, but also allow it to help develop some of these types of planning documents and program design concepts at a much lower cost than might be obtained from a much larger utility.
But do you have any knowledge of any of those departments having ever designed an EEDSM program for a utility? Do you have any knowledge of that?
No, not having designed one.
And you don't know what the cost would be per customer or per kilowatt hour to implement your recommendations on page 44, do you?
No, that is the point of the planning process.
Yeah. And you don't identify any specific revenue stream to fund the types of DSME programs you've identified, do you?
Not in this testimony, no.
No.
I am aware of available funds.
No further questions. Thank you.
Redirect from Appalachian Voices.
Thank you, Commissioner Cameron. Just a couple questions for you, Mr. Hoyle. During, I think it was counsel for the public staff, they asked you a couple of questions with respect to, I believe, I'm recalling correctly, the DCF analysis, specifically the fact that the public staff had recommended and conducted a DCF analysis in its own testimony, and that the stipulation ROE and ROR were a function of that DCF analysis. Do you recall that line of questioning?
Somewhat, yes.
Do you at any point recall seeing in any of the settlement testimony that was filed with the stipulation any reference to the DCF analysis being, I guess, the product or informing the ROR cost of capital terms?
I do not call a reference to the DCF analysis in the settlement.
And does the stipulation at all talk to how New River on a going forward basis will optimize its capital structure or cost of capital?
No.
Okay, can you talk a little bit in some depth with respect to your recommendation specifically about cost of capital and DCF analysis? There's some questions from counsel for New River and public staff with respect to what you've recommended, and I think there's maybe just a little bit of a lack of clarity with respect to maybe the understanding of what you were recommending.
Yeah, so my recommended return on equity is based on the cost to procure debt, because that is the only type of capital that, as far as I'm aware of, New River Light and Power can procure. That is one of the key objectives from the Hope ruling, is that the rates of return be set to allow utilities to attract capital. There is a fundamental problem with discounted cash flow analysis, the risk premium analysis, the capital asset pricing model analysis that are typically undertaken, that is specific to New River Light and Power because of its status as an operating division of a nonprofit, state-controlled educational institution. That problem is that New River Light and Power doesn't pay dividends. It doesn't have shareholders. It doesn't have a dividend growth rate. So to begin with that series of analysis, you need to find comparable utilities on a risk basis. Well, the most fundamental risk that these analyses start with is dividend growth rates, right? That is an investor risk. And that simply just doesn't exist. There is no reasonable proxy for that with New River Light and Power. So to me, that was kind of a non-starter. I cannot identify utilities with comparable risk literally at the foundational level of these analyses. There are certain aspects of New River's operations that might be considered comparable, say its size like a municipal electric provider, but those don't have regulated rates. So those are not before the commission. We don't have methods related to those. So the closest thing is, what can we do to still fulfill the requirements of the Supreme Court? set a rate of return that is reasonable and provides access to capital. That's where we begin with the municipal bond ratings, plus the additional cash flow, the additional return necessary to allow New River to access capital.
And with respect to your, I guess, recommendation regarding the compliance filing, can you explain a little bit more about sort of what you had proposed with respect to what New River would file and the purpose of that compliance filing?
Yeah,
I can. So
this would be, I believe. Just bear with me. So this would, excuse me, this would be page 30. And I think just starting at line 9, you sort of start talking about what your specific recommendation is with the compliance filing and the need for sort of a comprehensive analysis.
Right. So there's a lot that is missing, in my opinion, from New River Light and Power's proposal. If you recall the testimony that was available, I believe they used 2 natural gas utilities as the complete list of comparable utilities, which to me suggests that they also have a difficult time finding comparable utilities on a risk basis. And they kind of skipped over the investment risk part and went to something that are distribution only utilities and looked more at operational risks than the initial starting point of investor risk. And well, I suggest that they follow up, develop some more information, and either explain why they cannot pursue this or develop a mechanism that would allow them to pursue it. As I've mentioned before, if you find a way around the comparable risks and you do manage to identify utilities that might be acceptable or comparable in risk to New River, you still run into the problem of growth rates based on dividend payments. The only way possible around that, since New River has no dividend payments, is to make a comparison on the basis of something that New River does have that these other utilities also have, and that is retained earnings. So there are ways that plausibly you could substitute in or conduct a discounted cash flow analysis, even if you are trying to compare New River Light and Power, nonprofit, with a division of a large for-profit publicly traded utility company. I did not take that approach, but I do recognize that it's an available approach that would get as close as possible to the type of comparisons that are normally presented to the commission.
Thank you. And I have 2 additional questions with respect to the line of questioning from the public staff. So first, at one point, Council for Public Staff, they had mentioned that based on the capital structure approved in the stipulation, that capital structure essentially was needed in comparison to the actual capital structure, the capital structure that you recommended, because a hypothetical capital structure was going to be more favorable to ratepayers. Do you remember that line of questioning?
Yes, I remember that.
But that would only hold if you have a, I guess, hypothetical structure that is coupled with an ROE that's higher than necessary. Would you agree with that?
Sorry, can you?
I can rephrase that.
Bring all that together into one.
Yeah. So basically, Council for Public Staff said we need the capital structure that was proposed in the stipulation because a actual capital structure, the one that was proposed, if you have that capital structure coupled with the ROE, that is going to be worse for ratepayers. Do you recall that?
Yes, I recall that.
That only holds if you have an ROE that's inflated.
Right. That would be, so if you applied the proposals from, in my opinion, the proposals from the public staff and New River Light and Power regarding the return on equity to New River Light and Power's actual capital structure, it's a well-recognized thing amongst the public staff witnesses and New River's witnesses that this would be a vastly excessive rate of return. So instead of considering or adjusting the ROE, they just adjust the capital structure to try to lower the overall rate of return. I prefer to deal in facts where facts are available.
Thank you. And then last question, Council Public Staff, they reference a bunch of proceedings and basically said that the ROR, and these are past proceedings involving New River, that the ROR that was agreed to, specifically the ROE that was agreed to in the stipulation, was lower than those prior proceedings. Do you recall that?
Yes.
Is it proper in determining what the right ROE is to refer to prior ROEs that were authorized or approved by the commission? Sorry. Is it proper in determining what the correct cost of capital is to refer back to returns on equity that were approved in other proceedings?
It could be. It depends on whether those proceedings are partly recent, but whether they also involve utilities with comparable risks.
Okay, thank you. Moving on to the line of questioning from New River's counsel. I believe you got a series of questions with respect to the Moody's Investors Service Report. That was the basis for your 1.25% additional coverage figure. Do you remember that?
Yes.
I guess just at bottom, your approach, again, would you agree it's based on the information that was provided by New River, based on the actual cost values that were provided in this proceeding?
Yes, that's where my capital structure came from, was the values provided by New River, as well as the cost of debt I proposed is what was provided by New River as their embedded cost.
And so you using basically the municipal bond rates, that's again, your attempt to find what were actual cost values that represent the financing costs that New River would experience if it were to finance capital.
No, that was actually an attempt to provide a risk-adjusted rate of return that would be assured, as closest to assured as we can get anyway, to allow New River to access capital. Their actual capital cost would be lower, even if they were obtaining municipal bonds, because I used the 5% rate. Right? That is the rate for a credit rating one level below the credit rating of Appalachian State. And so Appalachian State should actually be able to access capital at a lower price, a lower rate than what a worse off entity with a lower credit rating would be able to access capital at.
Okay. Thank you. And just a couple questions with respect to energy efficiency and demand side management. Council for New River asked a couple of questions with respect to sort of the cost of it implementing energy efficiency programs, creating a plan. You would agree that New River would probably be best placed to sort of provide information with respect to how much it would cost for salaried employees or other planning costs that would be incurred?
Yes, it would require significant input from New River and quite possibly Appalachian State as well to understand those details, as well as a general concept of what these plans might look like and involve.
Right. And in addition, New River obviously identified in its rebuttal testimony that it had applied for grant funding for these EEDSM programs, correct?
Yes.
Okay. And ultimately, sort of identifying these costs was beyond the scope of your testimony.
Yes.
Okay. No further questions.
Commissioner, I'd like to ask him questions if I can.
Ms. LaPlaca, going forward, if you have not reserved any cross-examination time, please let me know and I will give you some leeway. This is a little out of turn to allow you to ask a question. So I will allow you to ask a brief couple of questions, but keep it very brief since you did not reserve any cross-examination time and your cross-examination is out of turn after redirect has happened.
Okay,
So
thank you.
please be brief.
Thank you. Mr. Hoyle, Appalachian State University has a sustainable technology department, correct?
Yes, that's correct.
And within that sustainable technology department, they have building science experts, correct?
That's correct.
In fact, Lee Ball, who is the director of sustainability at Appalachian State University, has a advanced degree in building science. Is that correct?
I believe so, but I am not completely certain.
So you would say that there is quite a bit of expertise at Appalachian State University when it comes to building science and energy efficiency, correct?
Yes, I can say that for sure.
Okay, thank you very much.
Since the cross-examination was out of turn, is there any additional redirect from Appalachian Voices that is necessary?
No redirect.
So we'll move on to commission questions. And Mr. Hoyle, you have testified that you don't have any information or have not calculated how much, and this question relates to the DSM EE program testimony and your recommendation. And you testified that you don't have any information about how much DSM EE program would actually cost. What I'm more interested in is the funding for it, or how that cost recovery would be recovered. And you testified about grant funding. Are there any other mechanisms or ways that New River Light and Power could recover the costs other than through funding through grants?
Give me a second. I'm
Yes.
considering how to answer this. And New River Light and Power's financials, let's say their use of the debt instruments that they currently use, leave a lot of money on the table, or not actually on the table. They put a lot of money back in the bank's pocket. That is unnecessary and, in my opinion, kind of unreasonable. There should be, or New River Light and Power being managed like, or even close to the way that a utility would typically be managed in terms of its use of debt. You know, $600,000 in recent years. Numbers. Let's see. In 2023, here's when let's see, in exhibit, Mr. Halley's exhibit 13. There would be, New River Light and Power will be paying $665,000 on the principal on loans that it obtained in 2016 and 2020. That's very unusual. Some of those loans are financing capital projects that aren't even in service yet. They've been repaying the principal on projects before they're in service, even before, much less before they recover the capital cost of those projects through the depreciation expense in their rates. The terms of these loans are far shorter than the service life of this property. They are putting in property with service lives, depreciable lives in excess of 30 years. They are funding that investment with loans that have a term of 10 or 20 years, which means that creates a significant cash flow shortage. And that is certainly one source of funding that could be available. If New River Light and Power or Appalachian State were financing using debt in a manner that would be typical of a utility, then they would have a significantly larger amount of cash flow and significant amounts of money available to invest in these programs, also available to invest in other activities and other needs, such as, you know, reserves for volatile commodity markets.
So as a follow-up to that, to your answer to that, New River witness Miller testified that New River does not qualify for DSM EE cost recovery that would be available to other electric utilities pursuant to the general statute 62-133.8 and 62-133.9. Are you familiar with those statutes? And do you agree with his statement that New River would not have that type of cost recovery that other electric utilities would?
I am somewhat familiar with those statutes and the implementing rules of the commission in that regard. As far as the cost recovery part and New River's eligibility, to my mind, that kind of interacts with New River's very unique position in the commission As I recall, they are not considered a public utility under state law, but are still rate regulated by the commission. And I wish I could give you more of an answer, but I'm not an attorney. And I'm not comfortable trying to weave my way through that particular swamp.
Okay, understood. So let me check to see if my fellow commissioners have any questions for you. Okay, Commissioner Clodfelter.
Mr. Hoyle, based on your, some of the dialogue you had on redirect, it sort of a question that's really more for my curiosity, probably than how it may change the outcome of the case. Whether or not I get to the same place you do is something I haven't yet decided, but I do start with the same point that you make, which is that for purposes of Hope and Bluefield, comparability is a really important issue. And you discussed your criticisms of the company's attempt to use investor-owned regulated public utility gas distribution companies. I understand your critique, but that prompts the question of curiosity here. So what we've got before us here is at least in North Carolina, it's a little bit of a unicorn. You know, it's a state instrumentality of the sovereign, but it's can't charge its own prices. Its prices are set by another agency of the state based on cost of service and cost of capital. Well, is there another herd of unicorns running around somewhere else in the United States? Are there similar entities that are state instrumentalities regulated by state agencies, public commissions like this commission in other states? Have you gone looking for them?
I have not found any, aside from Western Carolina, which is in state with the same circumstances.
Right.
But I'm not aware of any. I have not seen any. In my company, we track utility regulations and regulatory commission activities in all 50 states. Nobody, as I said, I lead the rate case proceeding. Nobody in the past year and a half since I've been working there, 15 months, whatever, has sent me an email saying, here's this interesting, strange thing happening you might want to know about, like a unicorn. I've not found any that are treated similarly in other states. I mean, honestly, the issue goes back the same reason Western Carolina has a utility, right? The hydroelectric dam that was created in 1915 that has become what is now New River Light and Power. Well, it's the mountains. They wanted light for their teachers' school. It was going to be another 20 years before the Rural Electrification Act got passed. Who knows how long before they actually got the wires up there. So we're talking generations potentially of people that would not have had electricity for use in education. You know, had New River Light and Power not been created for that purpose, just like Western Carolina. But in terms of finding other utilities in the same circumstance, I have not been able to find any.
Or even other business enterprises, state-conducted business enterprises that may be subject to rate regulation. Railroads, for example, or other enterprises that might be subject to rate regulation in other states. I ask the question because if we can find them, I'd be interested in knowing how rate regulation and cost of capital is viewed in those circumstances. But we don't have that. You've looked for it and you can't find it.
Yes, I mean, I haven't looked for railroads. I've mostly focused on electricity companies.
That's fine.
But I understand what you're saying, and a more broad search with the broader scope that perhaps included the full scope of utilities could perhaps be useful just to identify what else is being done in other places.
Thank you. Like I said, just curious. Thank you.
And I believe that all of the parties are very familiar with how we handle questions on commission questions, but just as a refresher, any questions from the parties on commission questions have to be related very directly and very specifically to just the questions that have been asked by the commission. So beginning with the public staff, any questions on commission questions?
No questions. Thank you, Commissioner.
Okay, Ms. LaPlaca,
No, thank you, Commissioner.
New River?
Yes. The follow-up, Commissioner Clodfelter's questions. You referenced Western Carolina. It's the first time it's been referenced in this hearing room. Have you looked at the rate case results and the rate of return on equity that's been set by this commission for Western Carolina?
No, not recently,
Okay.
but I suspect it's been set in similar ways as New River Light and Power has been set in the past.
So subject to check, the most recent rate case in 2020, the cost of equity for Western Carolina was 9%. And in 2016, Western Carolina's rate of equity was 9.25%. Subject to check, would you agree with those numbers?
They are
Any
in
reason-
docket, right? But you could present them if you wish.
Finally, regarding the fact that this is sort of a unicorn, would you agree that in looking at rates of return, you look at overall risk? That's one of the driving factors, would be risk-adjusted rate of return, correct? As a financial principle.
For an equity investor, absolutely.
And so the risks include, and you've discussed financial risks, correct? It'd be financial risk would be one type of risk,
That would be one type of risk.
but there's also, in addition to financial risks, companies have similar operating risks, do they not?
Operating risks are another type of risk.
And so similarly situated utilities might have similar operating risks, would they not?
It's possible.
No further questions.
Mr. Hoyle, thank you for your testimony, and you may be now excused. We will hear motions from the parties. Oh, I apologize. Appalachian Voices, did you have any questions on commission questions?
Thank you, Commissioner
I spoke
Cameron.
too quickly.
No, it's all good. Just wanted, I had two questions, just real quick follow-ups. At one point you were asked just generally about the prospects of New River being able to avail itself of the EE rider for cost recovery. Do you recall that?
Something along those lines, yes.
And just want to kind of button this up, just as a general matter, you're aware of that, but ultimately at the end of the day, like, you know, you can't really opine upon this because that's kind of like a legal opinion, aware of the issues, but just not in a position to sort of share anything with regards to that.
Yes, I mean, I could say if their rates are New River's rates are regulated. Riders are generally considered a rate.
Okay, thanks. No further questions.
Mr. Hoyle, I was excusing you too quickly. Now you may be excused, and thank you for your testimony.
Thank you all very much.
I'll now hear motions from the parties, beginning with Appalachian Voices.
Thank you, Commissioner Cameron. At this time, Appalachian Voices would move to have Mr. Hoyle's pre-filed direct testimony exhibits and his pre-filed testimony be entered into record as though given orally from the stand, and have the exhibits attached to his pre-filed direct testimony identified as pre-marked. And again, we would move that Mr. Hoyle's live supplemental testimony that was given from the stand to today be moved into the record.
Okay. Seeing no objection, your motion is allowed.
Mr. Kimmerite, New River Light and Power would ask that New River Light and Power cross-examination Hoyle Direct Exhibit 1, previously identified, be moved in the record as evidence.
Okay. Seeing no objection, your motion is allowed. And before we move on to the next witness, Ms. LaPlaca, I think that we need to go back to your testimony because your exhibit was not moved into the record. Would you like to make a motion?
Sorry about that. Yes, I would like to move to have an exhibit put into the record, please. I brought 20 copies.
That's not necessary,
Okay.
but seeing no objection, your motion is allowed.
Okay,
Okay,
thank you.
thank you.
Thank you. Apologies.
And Appalachian Voices, you may call your next witness.
Thank you, Commissioner. Nick Jimenez with the Southern Environmental Law Center for App Voices. Appalachian Voices calls Justin Barnes to the stand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth to help you God?
I do.
And we are going to allow your attorney to make the introduction and request that testimony be admitted in the evidence, into the record, and then we're going to take our afternoon break for 10 minutes. So you may proceed.
Understood. Thank you. Mr. Barnes, please state your name and business address for the record.
My name is Justin R. Barnes. My business address is 1155 Kildare Farm Road, Suite 202, Cary, North Carolina.
And could you briefly describe your role and responsibilities at your employer?
I'm the president at EQ Research, which means I largely oversee a lot of EQ Research's policy tracking products, regulatory tracking, legislative tracking, general rate case tracking, IRP tracking, as well as oversee a lot of our consulting projects, specifically those that tend to deal with quantitative analysis, cost of service, rate design, and that sort of thing. I also periodically offer expert witness testimony on those topics.
Mr. Barnes, did you cause to be pre-filed in docket numbers E-34, sub 54, and sub 55 on June 6th, direct testimony consisting of 75 pages, including 4 exhibits?
I did.
Do you have any changes or corrections to your pre-filed testimony at this time?
I don't have any corrections.
If the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
They would be.
Were the exhibits to your testimony prepared by you or under your direction?
Yes, they were.
Mr. Barnes, did you also cause to be pre-filed in those same 2 dockets on July 6th, a summary of your testimony consisting of 5 pages?
Yes, I did.
Moving to the stipulation, have you had a chance to review the agreement and stipulation of agreement between New River Light and Power and public staff filed on July 6th?
Yes, I have.
Have you had a chance to review the settlement testimony of Randall Halley filed on behalf of New River Light and Power in those same 2 dockets on July 6th?
Yes, I have.
And have you had a chance to review the settlement testimony of John R. Hinton and James McClawhorn, both of which were filed on behalf of the public staff on July 6th?
Yes, I have.
Please briefly describe the stipulation terms concerning Schedule NBR, the proposed net billing schedule, if you would.
Well, basically, the stipulation adopts Schedule NBR largely as New River Light and Power proposed it. That includes the New River Light and Power's proposed supplemental standby charges. Those are incorporated in slightly different amounts due to other changes that affect the revenue requirement. And I presume New River Light and Power's addition of separate standby charges for the commercial class and the commercial demand class, but kind of more or less the stipulation adopts New River Light and Power's proposal with the review of Schedule NBR and the supplemental standby charges in 5 years' time.
What concerns do you have with the stipulation's provisions concerning Schedule NBR?
My concern is that the customer class supplemental standby charges, the SSCs, as reflected in the settlement testimony and exhibits, failed to accurately reflect cost causation. The class SSCs incorporated within the settlement are based on a flawed methodology for assessing the cost that New River Light and Power avoids due to the installation of customer-sited solar because they retain the same basic calculation and mathematical errors that I described in detail in my direct testimony. Specifically, those calculations inappropriately underestimate the benefit side of customer-sited solar cost-benefit analysis in 2 significant ways. First, they base the calculation of avoided costs for demand-related costs on an averaged flat volumetric rate, which fails to account for the fact that New River Light and Power incurs demand-related costs based not on average demand, but demand that is coincident with the timing of its monthly peak. So costs based on coincident peak demand. Second, those calculations entirely ignore the potential value of avoided distribution costs. Both aspects are contrary to proper cost-benefit analysis and together result in an inflated SSC that will ultimately overcharge customers that install on-site generation.
Okay.
That concludes.
In light of those concerns, what recommendations do you have for the commission regarding the stipulation?
I recommend that the commission, to the extent Schedule NBR portions are severable from the rest of the stipulation, reject those portions and adopt my recommendations for the establishment of Schedule NBR as described in my direct testimony.
Okay. Commissioner Kemwright, I would move to have Mr. Barnes' pre-filed direct testimony and summary entered into the record as though given orally from the stand, and to have the exhibits attached to his pre-filed direct testimony identified as pre-marked exhibits JRB 1 through JRB 4 entered as well.
And can you clarify the number of pages in the direct testimony? I thought you said 75 pages, but my notes show 56 pages. So can you provide some clarification?
That was including exhibits.
Okay, including exhibits. So Mr. Barnes's direct testimony filed in this docket on June the 6th of 2023, consisting of 56 pages of testimony, will be copied into the record as if given orally from the stand. And exhibits 1 through 4 will be marked for identification purposes as pre-filed.
Thank you. I would also move that we move his live supplemental testimony into the record.
Okay. Your motion is allowed. And with that, we are going to take our afternoon break, and let's be back at 3:50. We'll take a short 10-minute break. Go back on the record.
Madam Chair, rather, Commissioner Cameron, I think we've covered the bases. The witness is available for cross-examination and questions from the commission.
And Ms. LaPlaca, you have not reserved any cross-examination time. Do you have short cross-examination that you wish to do, but you did not reserve any time?
Yes, ma'am, I would. I mean, I do apologize. I keep it short.
Okay, please proceed.
Mr. Barnes, you stated in your testimony that the cost of solar is very close to the cost of the new retail rate, which I think is 14.8 cents a kilowatt hour, if you include the avoided distribution capacity costs. Could you walk us through that, please?
Well, I think what I calculated was the value of customer sited solar as approximately the same as the retail rate. And in my testimony, there is a table in which I basically conducted several different effective capacity contribution scenarios for solar, as well as using some of the company's data to define effective solar capacity contribution. And in those calculations, without any avoided distribution value, on average, based on residential class billing determinants, the value of customer sited generation comes out to about 80% of the retail rate. If you layer in some additional distribution value, just based on unit costs associated with the company's embedded distribution costs, that's when you get a number that potentially exceeds the residential retail rate. As I emphasized in my testimony, those embedded costs are not marginal costs, and the remainder of my analysis is based on marginal costs. I had to use embedded costs simply because I didn't have any marginal cost information available. But I think what it demonstrates is that even at a substantial discount to the company's embedded distribution costs, the value of customer sited DG is approximately the same as the retail rate.
And Mr. Barnes, can you give us some numbers on that? I think one was like 11.1 to something cents a kilowatt hour, and then the avoided distribution was like 1.1.
If I can find my table, I can
I
relate
can-
the specific numbers.
Okay.
I don't remember exactly what page it's on.
I think I have it right here. It's your testimony, direct page 4.
Okay, yeah.
Lines 5, 6 to 8, 5, 6, 7, 8.
Okay, I'm looking at table 3 at page 28. And so the range I see based on different solar system orientations and, resulting in different effective solar capacity contributions is 11.8 to 12.8. That's without any distribution value. And then with distribution value, anywhere from 17.1 cents per kilowatt hour up to 18.9 cents per kilowatt hour. Again, that's depending on how you calculate effective solar capacity, basically the ability of solar to avoid costs. And that depends on the production profile of the solar system and what direction it's oriented in relation to times of coincident peaks on New River Light and Power system.
I have no further questions. Thank you. Thank you, Commissioner.
No questions from public staff.
Questions from New River?
Please. Mr. Barnes, just on that last point, as I look at that table on page 28, you also had mentioned in your testimony some missing solar data in the calculations performed by the New River witness. Is that right?
That's right. There was, I believe the number was approximately 30% of daylight hours missing from the company's solar data set.
30% within a certain time frame, right?
Well, within the solar production window, which is
Okay.
kind of what matters.
Okay. And so Mr. Halley had, and this is a question, he had used, my understanding is actual solar production data from the AMI metering. And then for the missing parts, he had interpolated based on the actual data that was in nearby in time. Is that your understanding as well?
Yeah, he interpolated it, but he did it wrong.
Now, when you did your analysis, you did not use actual data. You used modeled data. Is that right?
That's right. I used PV watts, and the reason I used different solar system orientations was because, of course, not all systems are going to be oriented directly south. Typically, you try to orient them in a southward direction. So the range of solar capacity contributions that I calculated and that range of ultimate solar values is based on basically a range from southeast to southwest in terms of solar system orientation.
And that's not actual data, that's modeled.
It's a hypothetical PV watts solar production profile.
Thank you. I wanted to ask you some questions about use the minimum system method in the cost of service study versus the basic customer method. And I believe this is a subject you're familiar with from prior cases as well. Is that correct?
Yes, it is.
Okay. And you understand that Mr. Halley used the variation of the minimum system method in his cost allocation analysis.
That's something I'd actually like to clarify because I believe in his rebuttal, he said he used a modified minimum system method.
Right.
A minimum system analysis is an actual analysis of the minimum size system required to support basically any demand or, the typical, say, average residential customer. As far as I can tell, Mr. Haley did not perform any such analysis. He simply calculated his modified minimum system analysis was just assuming that all class costs of all distribution costs were customer related costs. That was his modification. I don't consider it an analysis.
And that modification actually is more favorable towards your position than if he had done the traditional minimum system method, isn't it? Loaded less cost on.
I would not imagine it would be, because a typical minimum system method would only classify a portion of the distribution system as customer related, whereas, at least as I understand Mr. Haley's numbers, his $36 a month is based on the entirety of the company's distribution system. So not a portion.
Okay. Are you opposed to use of the minimum system method?
In particular, I am opposed to it for the purpose of setting basic facilities charges.
Right.
I have not necessarily always taken the position that there can't be some customer related component when it comes to cost allocation.
And in this case, you provided 3 alternative methods for calculating the basic facilities charge. Is that correct?
Yeah, I did.
And the first method, not that there's any particular order, is the basic customer method.
That was one method I used.
Yeah. And your $10.61 figure is based on that basic customer method?
Right. That's based on the costs of metering and service drops, depreciation expenses, return on meter and service drop plant, as well as essentially like billing and administrative expenses.
Do you know if the basic customer method is one of the methods that's in the National Association of Regulatory Utility Commissioners, or NARUC, Electric Utility Cost Allocation Manual?
It's not, and that's a cost allocation manual, not a description of how to set basic facilities charges. I will note that in the past, although I didn't do so in this case, there was a letter submitted by several commissions to NARUC after they published that particular manual, voicing disappointment and displeasure about the fact that the basic customer method had been omitted in the final draft. I believe that was signed by commissioners in Washington and Arizona at a minimum. I'd be happy to provide that to the commission if they would like to see that.
That was not signed by North Carolina commissioners, was it?
Not that I recall, no.
Okay. So you had mentioned this distinction between cost allocation and setting a basic facilities cost charge, which is, I guess you could say, rate design. Did I have that correct?
Yeah, rate design and cost
Okay.
allocation do not necessarily have to be identical to one another.
does cost allocation essentially mean cost causation?
It's one reflection of cost causation, typically about the best we can do with the fact that we possess incomplete data. And, it's very complicated to assign specific costs of service, for large interconnected systems with lots of unique customers.
Right. It's fair to say there is no single perfect cost of service methodology, right?
Yeah, there is not.
Yeah. So getting back to this cost allocation versus rate design, would you agree that cost causation is a very important part of rate design?
Yeah, it is.
Okay. Your second method, and you may have to help me on this, as I understand, is to base the basic facilities charge on some modifications you made to customer-related cost that New River had included in its cost of service study. Is that correct?
Yeah, that's correct. It was basically, there's a column in the company's cost of service study where an expense has been designated as customer related. There's a little seat next to it. And then those costs are summed to a quote unquote customer related revenue requirement at one portion of the cost of service study.
And are some of the costs that you recommend removing demand related costs?
No, the adjustments that I made to in that derivation were primarily the company had for several of those line items, among them the unrelated business income tax line, as well as regulatory commission expense, a few of these kind of like general expenses of the utility, had allocated those using a revenue factor. In other words, the allocation to the residential class was based on basically residential revenue as a portion of the utility's overall revenue. But the company had classified all of those costs exclusively as customer related. So the primary modification that I made in, I think what I referred to as my New River Light and Power modified cost of service analysis was that I essentially said that, well, not all revenue or not all of the company's revenue is associated with the customer charge, and therefore only a portion of a cost that is allocated based on a revenue factor should be considered customer related, about 10%. And so the main modification I made was to basically prorate that by down to about 10% rather than have it be exclusively kind of logged as customer related.
And so the cost that you removed from the basic facilities charge, which is a fixed monthly charge to customers, would then be recovered in the KWH volumetric charge?
Yes, presumably they would.
And are all those costs directly proportional to KWH usage?
No, but nor are they directly proportional to the number of customers. And one of the best quotes I've ever seen from a rate-making expert from John Bonbright, who urges us not to let the category of customer-related costs become a dumping ground for all costs that we cannot plausibly attribute to another cost factor.
Does that mean volumetric should become the dumping ground?
Volumetric has historically been, in part, dumping ground because at the basis, we're not, when we sign up for a utility, what are we asking for? Electricity.
Okay. The third method, as I understand your testimony, is you take the dollar reduction to revenue requirement that would result from Appalachian Voice's cost of capital recommendation, and you use that, you subtract that entirely from the basic facilities charge rather than having any of that lower the volumetric rate. Is that correct?
Yeah, that's correct.
Okay. And that has nothing to do with cost causation. That's just a way of lowering the basic facility charge to reduce the basic facility charge, right?
It has the objective of placing a priority on supporting customer investments in energy efficiency, which I think is particularly compelling given that the company has been a bit resistant to offering DSM programs. Therefore, the price signal sent by a volumetric rate, can be a reasonable compromise for providing that kind of incentive where no other incentive exists. It's a policy decision.
Okay. Would it be a little bit clearer policy-wise if you want to insist on EE programs, just to mandate them and fund them instead of trying to create that incentive through the back door by reducing the basic facility charge?
Well, I mean, the basic facilities charge that derives from that estimate is actually higher than the basic facilities charge that I recommended based on the basic customer method. I think the basic customer method is the most methodologically sound way to arrive at a basic facilities charge. So, that was it's another example of the fact that none of these numbers are necessarily as precise as they look on a piece of paper, because cost of service analyses are not precise in that way either.
Right.
So, but the three numbers, I think, present a very reasonable range for the commission.
Did you oppose use of the minimum system method in the Duke Energy Carolinas case, docket E7 sub 1146 that was decided in 2018?
If I remember correctly, I opposed it for the
For use of the
For the-
basic facility charge?
yeah, for taking that number and then applying it directly to calculate the basic facilities charge.
I'd like to hand out if I may, a collection of three cross-examination exhibits here. The first will be an excerpt, because the commission's order in sub 1146 is 400 some pages. I have excerpted the part that is specifically titled minimum system method. And we would ask that be marked. I'm not sure what our convention is because I don't have the label in front of me.
We'll mark it for identification purposes as New River Cross-Examination Barnes Direct Exhibit 1.
Thank you. And then I have a second cross-examination exhibit I would like to have marked for identification, which consists of the report of the public staff filed with the commission in E100 sub 162 on March 28th, 2019.
And Mr. Drews will have that exhibit marked as New River Cross-Examination Barnes Direct Exhibit number 2. Thank you.
And finally, we are handing out a third cross-examination exhibit that is the responses of New River Light and Power to Appalachian Voice's 8th set of written discovery requests. And that would be New River Light and Power Barnes cross-examination exhibit number 3, I believe.
So, Mr. Drews, the responses, what's been described as responses of New River Light and Power to Appalachian Voices, 8 set of written discovery responses. Is that the one you're referring to now?
Yes.
Okay. That will be marked as New River Cross-Examination Barnes Direct Exhibit number 3. And Mr. Drews, I think there's some confusion among the commissioners about which exhibit is exhibit number 1 and which exhibit is exhibit number 2. So if you can clarify which is 1 and which is 2.
Exhibit number 1 should be the excerpt from the E7 sub 1146 order of the commission.
Yeah.
The order issued June 22nd, 2018. Number 2, and I did these chronologically, is the report of the public staff E100 sub 162 that was issued March 28, 2019.
Okay. Thank you.
So the number is in chronological order.
Thank you.
So Do you have copies?
No,
Heath?
I was not furnished a copy.
Okay, well, that's important, and I want to give you a second to take a look. Okay. Just so I have the exact same.
So which
If
which is which? Okay, so this is the third. No, that's the first.
We're still missing. These two. This is on this. Mr. Cruz, you may want to just witnesses benefit, go through which one's 1, 2, and 3 again.
So number one is the excerpt from E7 sub 1146. Number two is the E100 sub 162 document. And then the data responses are number three. Okay, so we'll start with number one. You'll notice in the first paragraph where it starts minimum system that the company, which refers to Duke Energy Carolinas, used minimum system study to allocate distribution cost among customer classes. It goes on to say NCSEA witness Barnes objects to the use of minimum system study to allocate cost to customers. Is that correct?
That's what the order said, yes.
Yeah. And did you in fact object to use of the minimum system study for that purpose?
I cannot recall whether I objected only to the use for defining the basic facilities charge, or whether I objected to both its use for cost allocation and designing the basic facilities charge. I don't have a copy of that testimony. I'm not positive that, maybe there was something lost in translation in the commission's order.
Okay. Let's turn to what's numbered as page 87 at the top. That'll be, I think, the fourth page in this exhibit. And you'll see in the second full paragraph, the commission recognizes the importance of addressing issues such as those that you discussed in that case, in that first sentence on the second paragraph, right? And if you follow down, does it also indicate the commission directs the public staff to facilitate discussions with the electric utilities to evaluate and document a basis for continued use of the minimum system, et cetera, and the public staff shall submit a report on its findings to the commission. Is that correct?
Yeah, I recall that when it was issued, and I've been reading it now.
And then in terms of how they resolve the issue in that case, will you read the last paragraph in this exhibit into the record, please?
You mean the third paragraph on?
Yeah, the one that starts upon consideration.
Upon consideration of all the evidence in this docket, including the stipulation, the commission approves DEC's use of the minimum system methodology for cost allocation in this proceeding. The commission places significant weight on the testimony of company witness Haggard regarding the company's long history of employing the minimum system method and this method's alignment with cost causation principles. The commission finds that the company's use of the minimum system method for cost allocation in this proceeding is just and reasonable to all parties and in light of all of the evidence presented.
And do you have any information that would contradict the idea that the minimum system method, there's been a long history of its use by utilities in North Carolina for purposes of cost allocation?
I'm aware that it was used, certainly at least in the rate case prior to this one, because I seem to recall reviewing like the calculation prior to that time.
Mm-hmm. And was that used to inform the decision on basic facility charges in those cases?
I presume it probably was, but I don't specifically know.
Okay. If you'll turn to the second cross-examination exhibit, the one from docket number E100 sub 162. And I will submit to you and the commission that this exhibit contains the public staff's report without their appendices. Because again, that would have been another 50 pages of numbers that I don't think would have been productive, but it's on file with the commission should anyone want to review that. And will you turn to what's numbered as page 15 in this exhibit? And you'll see a highlighted sentence down there. Could you read that into the record, please?
The public staff has traditionally advocated a position that supported a basic customer charge based on the utility's MSM, while recognizing that full movement would likely result in rate shock for many customers, particularly low income and low usage customers.
And could you read the sentence at the bottom of page 16 and top of page 17?
After our review, the public staff believes that the use of the MSM by electric utilities for the purpose of classifying and allocating distribution costs is reasonable for establishing the maximum amount to be recovered in the fixed or basic customer charge. While not precise, MSM is a logical methodology for classifying costs of a distribution system as demand or customer related.
So when you came up with a basic facility charge, in this case, that you recommended at $10.61 based on the basic customer method, that's really something of a departure methodologically from what has been used previously and what has been suggested as the basis for the maximum BFC in the public staff's report, isn't it?
Well, public staff and I have a clear disagreement on the proper methodology. I think that,
Okay.
I think my words speak for themselves on
Fair
that
enough.
front, and theirs do their own.
I understand. If you'll turn to the third exhibit here, which is the response to data request. And turn to item 8-1, which is on the third page.
On there.
And part B there says, please identify specific commission decisions that support witness Halley's statement. My approach is more in line with past North Carolina utility regulation than the approach offered by Mr. Barnes. And in the response, you'll see citations to some cases. And if you turn to the next page, page 4, there's a reference to docket number E100 sub 180, the commission order of March 23rd, 2023. Do you see that?
I do.
Okay. And do you know what E100 sub 180 was?
The Duke Solar Choice docket.
Okay. That's Duke's net metering docket, right?
Yeah, the residential successor. There's
okay. And this is not in the original, but emphasis I added. Could you read from the footnote that's quoted there, the bold underline statement?
The commission has to date accepted Duke's cost of service studies and set the basic facilities charge at levels that are less than Duke's cost of service studies show are necessary for full recovery of its fixed cost of service.
And that's essentially what New River's recommending to the commission in this case, isn't it? They used a minimum system study methodology and recommend a basic facility charge that's actually less than the fixed cost that their study suggested.
I don't disagree that New River Light and Power's proposal of 1450 is, I think fairly well in agreement with that particular passage. I disagree with it from the standpoint of an expert.
Right. And that's what experts do. Thank you. That's all my questions.
Redirect?
Yes, Commissioner, thank you. So, Mr. Barnes, going back to beginning of the conversation you had with Council Drews. At the very start, you were discussing the missing solar data in Witness Halley's analysis. And you described how you used model data from PV Watts. Why is PV Watts better than Witness Halley's approach?
You're faced with the question of relying on data which you know to be incomplete, which, you're missing 30% of values for daylight hours, which is one thing. Do you necessarily trust the rest of the data because you're missing so much? And do you have a reasonable methodology to fill that data in? Those are questions that were percolating in my mind as I was kind of evaluating what to do with this. There is some level of imprecision associated with using hypothetical solar production profiles because they don't necessarily represent, the average of all customers, whereas presumably a full data set of the type Mr. Haley presented, if it was full, would, provide actual information. I think what I conclude from my analysis is that when I run the numbers using my hypothetical scenarios, run the numbers using Company Witness Halley's unadjusted scenarios, and then run those same numbers again after correcting some other errors in Company Witness Halley's methodology, the end result all ends up being fairly close to the same. Which leads me to believe that there is nothing wrong with my use of a hypothetical solar production profile as reasonably representative of what customer systems in New River Light and Power's service territory look like from a production shape standpoint.
Okay, moving to your discussion of energy efficiency. Council asked you something to the effect of, wouldn't it be easier to mandate energy efficiency than to put fixed charges into the volumetric rate and encourage energy efficiency that way? If a utility really wanted to encourage energy efficiency, couldn't it do both?
Sure. It's not, the volumetric rate is one arrow in the quiver. Time varying rates could be another arrow in the quiver with respect to supporting demand reduction and conservation. Proactive and targeted demand response programs are another way of addressing the same. Ideally, you would use them all. But when forced to rely on, a limited scope, I kind of use the tools at my disposal to offer one suggested approach.
Okay. So you also had this sort of deep dive into previous filings with council. I want to bring you back to what I hope is Exhibit 2, the report of the public staff. And if you'll look on page 17, so I wrote down the words, I believe this is right. You said there was a disagreement between you and the public staff on the sort of merits of the minimum system method and ways to set up a basic facilities charge. On 17, beginning right after the highlighting at the word however, could you read that sentence in the following bullet, please?
The minimum amount recovered in the fixed charge for any rate class should be the amount determined by the basic customer method, which reflects the customer meter, service drop, and any other facilities uniquely attributable to specific customers that are not already recovered through extra facilities charges.
Thank you. Okay, one more question on this exhibit. Recognizing you might not have reviewed this in its entirety at any point, in what you have seen today, did you see the public staff say anywhere that it's inappropriate to use the basic customer method?
I guess the best I can say is I don't recall the commission in any rate case order ever establishing a specific methodology with which to set the residential basic facilities charges. Some of the passages which Mr. Drews asked me to read were focused primarily on cost allocation rather than rate design. Plausibly, there is a specific finding, saying this is the way to set the BFC that I'm not aware of, but I don't recall that in from having read past commission orders.
Or that it's prohibited?
As far as like it's prohibited to use the basic customer method as a method of setting the basic facilities
Right.
charge. No, I'm not aware of any limitation that says it's prohibited.
Okay, that's all for me. Thank you.
Mr. Barnes, I have a couple of questions for you, following up on your attorney's last questions. In regard to the basic customer method, you just testified that you were not aware of any commission order that says that use of the basic customer method is prohibited. Can you cite to us or point us in the direction of any utilities that use that or the commission that has approved the basic customer method for either cost allocation or determining the residential basic facilities charge?
I could certainly do so in kind of cited format in a post-hearing request if you would like. It is information I've included in testimony on this issue in the past. I just happen to have not done so here. Orally, the places where the basic customer method are used exclusively, the state of Texas, the state of Maryland, the state of Massachusetts. There was a recent finding in New Hampshire that was in agreement with that. Historically, it's been used in West Virginia. Tried to think of, those are the ones I'm kind of coming up with off the top of my head. My recollection is that there are approximately, 20 to 25 states that use the basic customer method with a certain amount of variation in between exactly how they make the calculations.
And I think what I'm interested in is in North Carolina, if you have any examples of the basic customer method in North Carolina, then you could provide that in a late filed exhibit, not in other jurisdictions, but in North Carolina, if you can cite to anything specific for orders or for utilities.
I do not recall any in North Carolina.
Okay. Okay, well then a late filed exhibit will not be necessary unless you come up with something and you would like to provide, then we would accept a late filed exhibit. And then starting on page 4 of your testimony, you've provided a recommendation that New River's proposed schedule NBR be modified to eliminate the annual forfeiture of the net excess credits on an annual basis on January the 1st. And then I think your alternative position is that if that is not allowed by the commission, that the customer be able to choose their annual period as opposed to relying upon the certain date of January the 1st. Can you provide some information or talk about whether having the choice about what that annual period would that be an administrative burden to New River Light and Power, or how would that work from a practical standpoint?
Well, I mean, typically the way it's been practiced in other jurisdictions where there wasn't a set date and the customer could choose it is that the customer would just pick a date at the time of their interconnection application, and it was a one-time election that they could never change. And that would be logged with the system. And I mean, as far as I know, as long as you can bill monthly, it has not been inherently problematic anywhere else.
Okay, and then you also state, this is also, I believe, on pages 4 and 5, that the indefinite rollover would provide a deterrent against oversizing of the systems. And can you provide a little bit better or more explanation about why you think that would be a sufficient deterrent?
Well, so to the extent if you're using indefinite rollover, that basically means that there is never a reset. You're never, kind of permitted to cash out your account and, take any form of monetary payment at all. So if you install a system that produces 50% more than what you need to supply your on-site needs on an annual basis, all you're going to do is just continue to accumulate credits that you can never redeem. And so that's the kind of inherent incentive that indefinite rollover provides from the standpoint of system sizing. It helps remove what has sometimes been a level of contention when customers are attempting to document what system size is necessary to support their expected electricity usage, and don't have a full history or have missing months or just moved into a house or are going to have like a new load, like a new heating system or a new AC system or a new EV. Like there are a lot of reasons why an annual historic average may not accurately reflect future usage, but as long as you're using indefinite rollover, you're kind of just putting the onus on the customer to, well, you're giving away free electricity to the utility if you oversize it intentionally. So just don't do that.
Mhm. And that would be kind of the same situation if there was that reset on an annual basis as well. Unless I'm not understanding your testimony, wouldn't that also work as a deterrent as well?
Well, yeah, an annual reset kind of inherently does that as well. My concern is that one on January 1st would be potentially harmful to some consumers by causing them to forfeit, by causing them to never be able to fully offset their electricity consumption, because it's not as though their electricity consumption is consistent from month to month. So a January 1 reset, they may have been saving 500 kilowatt hours that they would have otherwise used in January and February, but instead they're not able to do that. If they are able to choose their date, that's an improvement. It doesn't serve to kind of avoid the issue of sizing disputes, though.
Mhm. Okay. Thank you. So I'll look to my fellow commissioners to see if they have any questions. Chair Mitchell? Okay. Commissioner Clodfelter?
Mr. Barnes, only one question really on the basic facilities charge, the fixed monthly charge, I'll call it because it's easier to keep the naming convention separate. The fixed monthly charge, I have the exhibits that we offer up in 1146 that show the use of the different methodologies among the various states at that point in time. And I would actually be interested in seeing, as a late filed exhibit, an updated list to see what may have changed since 2017 in terms of the use of different methods for establishing the monthly fixed charge. So if you have a current version of what was offered as an exhibit in 1146, I'd be interested in seeing the current version as a late filed exhibit.
Okay, I don't have an absolutely current version, but I definitely have an updated version, which might be up to date as of like 2022.
And I don't know what exhibits that refers to in 1146. I don't know if you have something more specific.
Well, I don't have the exhibit number off my head right now, but it's in the record of the case. I will commit to, through the appropriate channel, probably through Commission Counsel to you, get you the exhibit number that references out of the docket from 1146.
Thank you.
Yeah, but it's there. Mr. Barnes offered it. I recall the testimony very well. You were asked a lot of questions. I just have to ask this so the room is not silent on the point. It's sort of interesting. You asked a lot of questions about whether the commissioners rule this way or rule that way, or has prohibited the use of the basic customer method, or has endorsed it here or there. Are you aware that the legislature has actually spoken to this question since 2017?
I recall the passage of a section of North Carolina law that says requires the use of minimum system for cost allocation and says does not necessarily need to be used for the purpose of setting.
I wasn't going to ask you to read the law, interpret the law. There's too much of that goes on around here, but I just didn't want the room to be silent, thinking that the only thing we knew about was commission decisions. Thank you, sir. I'm going to move to the NBR. And I have some questions for you. I'm going to ask a lot of these same questions of Mr. Halley and maybe one or two from Mr. Miller, but this is my only shot at you, so I have to ask them of you too to see what your answers are. I'm going to read you something. You don't need to have it in front of you. I'm going to read it from the rebuttal testimony of Mr. Miller. And Mr. Miller says, and I quote from page 6, beginning at line 12 of his testimony, he says, NRLP has adjusted the amount of renewable energy utilized in its development of Schedule NBR and Schedule PPR to recognize the portions of the hourly load data missing from its initial analysis. This revision is shown in middle rebuttal exhibit number 1. I call it, this is the missing data issue that it speaks to. Have you reviewed Miller rebuttal exhibit number 1?
I recall reading that passage, but I don't recall the exhibit itself.
So you couldn't really talk to me about the exhibit then, if you don't even recall it. The question I was going to ask you was does the rebuttal exhibit number 1 supply actual data that was previously missing, or is it interpolated according to some method?
As far as I don't know how you would kind of reconstitute actual data if you've already lost it. So I guess I can't say specifically, but I find it doubtful.
Well, I'm as I say, I'm going to ask Mr. Halley these questions too, but I want to know what you know, because this is, again, your chance to tell me. Is the quote unquote missing data, is it just gone? It doesn't exist, or was it not captured in the first place, or was it lost along the way somewhere? What's your understanding from your investigation of the matter?
I guess I don't know where it went. All I can say is that, like, the duration of the kind of missing data might be an hour on this day and then 17 hours on the next day. And then, so what happened to it? Was it not recorded, or was it, lost somewhere else? I just don't know.
Okay. So you've told me all you can right now about the missing data issue.
Yeah, I mean.
Okay. That's fair. That's fair. I want to understand something else about the NBR rider here. Have you, in your view of NLRP's customer base, have you looked at their customer set that has currently solar PV installations?
It's about 14 residential customers.
About 14 total?
Yeah, that was the sample size for that data set of PV production data. As far as I know, that's all of their DG customers.
Those are residential. Are there any commercial customers?
I don't think there are any commercial. I recall that for the purposes of calculating those of Witness Haley's calculations, he excluded, I think, one App State windmill from the data set. So
because App State wouldn't be an NBR
right exactly.
eligible customer anyway.
So yeah, so if I remember correctly, there were 15 customers in the initial sample, and then for the purposes of his calculations, he removed this one customer, which is this App State windmill.
Well, again, I'm going to ask Mr. Halley this, so we'll validate it once we get there. But I in order to set the predicate for the questions I really want to explore with you, I need to get some background information set first. Are those 15 customers that you're aware of all single-family residential, or are any of them multifamily?
I have no idea.
Just don't know. Do you know the average or the typical size of the installation?
No, I asked for system sizes, but they didn't have the info for all of them.
Didn't have it? Did you get it for any of them?
I did get it for a subset. And
what's a subset of 15 is a pretty small number.
Yeah, there were a few. There were just a few. I think it might have been 5. It is in one of our discovery requests. They did list the AC generation capacity for at least a subset of those systems.
Well, here's where I'm getting at. And again, I'll ask these questions because it may speed us up tomorrow with Mr. Halley, because I'm going to ask him the same questions. Is what I'm trying to get a sense on is, since the SSC is going to be assessed on a kilowatt per month basis based on nameplate capability, I'm sort of interested in knowing the average or the typical size of a customer installation, so I can sort of say, well, the typical customer is going to be paying an SSC monthly charge of X. That's really, it's as simple as that. I'm just trying to get a basic number, and I can't find that anywhere in the testimony or in the exhibits. You don't have it either.
Yeah, I mean, I don't think the way the company responded to discovery, they didn't know exactly that number. if you were to trying to kind of just triangulate on a rough number in your head, if you take what I think was total generation, which is approximately 50,000 kilowatt hours. No, I'm going to butcher this if I try to do it in my head.
Don't
so-
do it in your head. Again, I'm just trying to, and again, Mr. Halley can help me with this. I'm trying to get a sense again of what a typical customer with a PV installation is going to pay by way of the SSC charge on a monthly basis if this rider goes into effect and the customer takes service under the rider. It's going to be $6.02 per kilowatt of AC nameplate capacity. And I'm trying to get a sense of what that feels like when it shows up on an average monthly bill. That's all. You can't help any more than what you have then.
Sure. Although I think in the settlement testimony, that number has been updated to, I think it's 592 per kilowatt. So
Okay.
slightly different with the revenue.
It's come in so
recognition.
quickly. I saw the reduction from 617 to 602, but I missed the reduction to what, 592 now?
That's right.
All right, well, I can go back and read it later, but I'll get it now. All right, so well, let's get to the question. So let's assume I'm not a solar PV customer. I'm not going to net meter. So this company needs to recover from me my allocable portion, my fair share of its fixed distribution system costs, which it says are, for me, $36 a month. It needs to recover that somehow or other from me. So it has two ways to do it now, right? How does it do it? How does it recover that fixed cost now from a customer who is not net metering?
Well, through the basic facilities charge and
Right.
the volumetric rate.
So a portion of it is used to set the basic facilities charge, a portion, and then another portion is recouped through the volumetric rate.
Correct. Yeah, that's
And
the volumetric.
And between the two, the expectation is that over the customer class, over the entirety of the customer class, the company will recover the full fixed cost of distribution for that customer class. That's the expectation.
The basic kind of cost of service equation.
Okay, so now I'm going to go on NBR and I'm going to put a 5 kilowatt array on my house and I'm going to try to sort of goose it up and see if I can run as much as I can off that. And so now I'm still going to pay the basic facilities charge, right? As I read the tariff.
That's correct.
And you read the tariff the same way. So I'm going to pay that. And if I'm a net importer, if I don't generate as much as I use, whatever I buy from them, I'm paying the volumetric rate I would pay if I weren't an NBR customer, right?
That's right. You would be paying, you'd be paying a portion of kind of the remainder.
I'd be paying a
at
portion.
minimum.
I might not be paying as much as if I were not an NBR customer. I'll be paying less of the portion of fixed charge that's included in that volumetric rate, but I'll still be paying some of that, right?
Right, you would be.
And the bigger the gap between what I generate and what I consume, the more of it I'm paying.
Sure, of course.
Right.
Yeah, I mean,
Okay, now I'm paying on top of that $5.92 or whatever the number is in the settlement testimony per month to go toward that fixed charge. So let's assume I've got a 5 kilowatt system. And humor me on this, I'll round it off because the math is easier for me to do this late in the afternoon. Let's call it a $6 charge. 5 kilowatt nameplate capacity, $6 a month per kilowatt. I'm paying $30 a month. I'm paying on top of that the basic facilities charge, which has some fixed cost recovery in it. Let's say I don't generate all of my consumption. I'm paying something at a volumetric rate. Where do I get the assurance that the company's not over recovering its fixed cost of distribution?
well, I think I think what the company would say is that its unrecovered fixed costs are not entirely within distribution, right? That there is a contribution from the other, transmission, Carolina Power Partners, that, the fact that you're paying $44.50 does not necessarily indicate that they're over recovering costs.
Okay, thank you for that help.
My response to that is that based on my calculations, even if we assume, say, like zero distribution value, in several cases, like the value of the customer sited solar generation, because of its contribution to peak, is more on a $1 per kilowatt hour basis than the flat average volumetric retail rate. And so, To the extent that there is some kind of under recovery of distribution costs occurring, you also need to consider that basically the customer is providing an additional service, but providing something of greater value than what they would otherwise pay for some of those other cost categories. So, they're kind of providing an in-kind service, not a monetary service, but they are reducing the company's other costs in a way that kind of at least will partially equalize what might be kind of missing on the distribution side. So my approach is that you need to kind of consider all of the different cost functions together, because in some cases, if you properly calculate the value of peak reduction for the company's Carolina Power Partners contract, it will invariably be higher than the retail rate because the company's costs for that are based on costs at peak.
At peak.
And if you have a decent contribution to those costs at peak, your value when spread across all solar production can be higher than the retail rate. So I think of it from the standpoint of is the customer a net benefit or are they a net cost? And if they're a net cost, how much are they a net cost? And that's what would determine if you were to establish, say, a standby charge, what that should be. My position is that the company miscalculates that and makes mathematical errors.
That's very helpful. Thank you. That is very helpful. Speaking of the errors that you call out in your testimony, I want to just clean up a couple of things. You indicated that you numbered them, and I'm sorry, I'll name them too. Issues 4 and 6, and issue 4 was the determination of the different SSC for commercial and commercial demand as opposed to residential. Are you satisfied that issue's now been resolved?
I'm satisfied that they proposed a.
You don't like the SSC, I understand that.
Yeah,
But the fact that they use the residential data to set the commercial charge, you're satisfied that's been cleaned up.
Right. They, at least in my understanding, they corrected the kind of mismatch between using residential data to set a commercial rate.
Okay, that portion of the issue has been clarified as far as you're. With respect to, I think you testified on cross and redirect that you're satisfied now with respect to the company's position, at least as I understand it, that it's agnostic on whether or not there's a reset or a continuing rollover. The company's essentially, as I understand it, leaving it to the commission.
Yeah, I mean,
You're satisfied with that?
That they voiced an openness to doing what the commission said. I mean, I suppose
Right.
they have to do that anyway, but I'm kind of gratified to hear that they're open and not opposed to it.
That's fair.
And I mean, just to be clear, to the extent that there are technological issues associated with that I'm not aware of, let's find a solution that's not contrary to customer interests and resolve those technological issues.
Okay.
So if there's a good way that's not exactly the way I recommended, that's still potentially fine.
Okay. I want to ask you about one that hasn't been discussed yet. And again, I'm going to ask Mr. Halley about these. What you called issue 5, I call as using the inverter rating as a surrogate for the AC nameplate capacity, even though the calculation is supposed to be based on AC nameplate capacity. Have you discussed that issue with the company and explained why that's not correct?
Okay, so the basic problem is that
I understand the problem. Have you discussed it with the company?
I've not discussed that with the company.
Have you discussed it with public staff?
No, I have not discussed.
Seems like that's a fairly easy one to fix.
I don't know whether it's.
But you've not made any discussions with any parties about how to resolve that issue.
Other than relaying my opinion and testimony, no, I have not.
Okay. Let me ask you a question about the PPR rate. So let's make the assumption for purpose of the question that the commission authorizes the new NBR schedule. So who are the customers who are still, after that, find the PPR rate to be of interest to them? Now, leave aside, I understand customers who are not eligible, such as ASU. I mean, they may need to look at a different rate schedule because they're not eligible for the NBR rate. I understand that customers who are have system sizes over 1,000 kilowatts would not be eligible for the NBR rate. So who are the types of customers who, and of course, as I read the tariff, people who are not buying from the utility at all, they're just perp QFs. They're not using the PPR rate. Who is left to use the PPR rate?
I think that's my point. I don't know. I don't know why anybody would. And I wouldn't want it out there kind of confusing people as an option. You know, 'cause
You've not been able to sort of characterize the type of customer whose situation or conditions might lead them to say, PPR, now that I've got NBR, now that I've got access to that, PPR is the right way for me to go.
It might be plausible that a commercial customer that wants to say depreciate their system and wants it kind of to be characterized as basically a power generator might find PPR preferable, but truthfully, like I mean, I feel like the customer benefit difference between NBR and PPR would be so great. I just don't see why anybody would want to do it unless for some reason they just have this urge to get a check. I don't see how it's financially beneficial relative to NBR.
Okay. Thank you, Mr. Barnes.
Good afternoon. I just had some follow-ups from Commissioner Clodfelter's questions to you, and you were answering one of his questions, and I wrote down the customer contribution at peak may be greater than the purchase rate, I guess, or tariff rate. Did I understand that correctly?
I might have butchered the articulation of it, but in a sense, yes.
Okay, but that's assuming that the customer can contribute at the peak.
Right, or it's kind of more assuming that the solar system is going to make some contribution at peak at the different hours. That's the basis of, that's when I talked about those different kind of solar orientation scenarios. I did those because different orientations of systems are going to have a different level of production at 5 p.m. or 9 a.m. And so there's always going to be some kind of derating of, the nameplate capacity because production's not going to be optimal at kind of typical peak times. But there will still be some. In my calculation, it was kind of mostly in the range of about 20%.
Okay, but if the peak is at 4 a.m. in the morning, there would be no solar contribution, correct?
Sure, except, I mean, none of New River Light and Power's peaks are at 4 a.m. in the morning.
Okay.
So,
Thank you. And then there was a question about the order in E7 sub 1146 about what the commission said with respect to basic facility charges. And I believe I heard your testimony was, we don't have that in front of us, and you cannot remember exactly if what the commission said about basic facility charges. And obviously the order speaks for itself, but subject to check, would you agree that the commission's order states that the commission finds and concludes that the increase in the basic facility charge for the residential rate class schedules is just and reasonable and strikes the appropriate balance, providing rates that more clearly reflect actual cost causation?
I seem to remember something along those lines, and subject to check, I agree that is something that the commission may have said.
And then later on in the paragraph, it states the commission agrees with witness Piro's testimony that the failing to properly recover customer-related costs via fixed monthly charge provides an inappropriate price signal to customers and fails to adequately reflect cost causation. Subject to check that the order states that.
Yeah, subject to check. My mission here is to hopefully correct that misapprehension.
Okay, thank you, sir.
And I have one follow-up from some testimony you provided to Commissioner Clodfelter talking about the PPR rate. And I think you testified that you believe that most customers would prefer the MBR schedule as opposed to the PPR schedule. And I think that you stated that you thought that the harm for having the PPR rate is that it would confuse customers. Is Is that the only harm? And in what way, because it seems like, what would be the detriment to having the PPR rate? And how would customers, from a practical standpoint, why would they be confused between these two rate schedules?
I mean, it's, in my experience, it's not that hard to confuse customers. You know, a lot of people don't spend a ton of time thinking about how a tariff reads and could see, you know, a number like we're going to pay you this amount versus you're just going to net your consumption against your production. And I'm not saying that like it would necessarily be common as a source of confusion, but I don't, you know, given that it's suboptimal from a customer standpoint in any circumstance I can imagine, I guess I don't see the need to have a schedule that's far less optimal than another rate schedule that the customer qualifies for. So even if one customer gets confused, that's too much for me, especially when I just don't see any benefit to it.
Okay, thank you. Any further questions? Okay, Commissioner McKissick.
I want you to help me with this, and if you could clarify your testimony. You indicated that about 20 to 25 states use the basic customer method.
I don't know the exact number, but it's similar to that.
All right, now let me ask you this. If you were to look back over, say, the last 5 years, is that trend increasing or is that trend decreasing based upon your knowledge? And you seem to be very astute in terms of having tracked this and followed this.
I would say it's relatively stable.
Stable.
Just from the standpoint of it's pretty typical that once a, you know, regulatory body kind of decides on how they want to do things, that just tends to, you know, there's a lot of inertia involved. One state where I can, you know, where I can recall it changing recently was New Hampshire, in which they decided that they made an affirmative decision, you know, making it clear in no uncertain terms that basic customer method is our method. In South Carolina, they've gone the other direction. Connecticut, they went more towards basic customer method, although that wasn't regulators, that was the legislature basically telling the regulators what to do. So I don't know that there's a clear trend either way. There have been some on one side and some on the other.
Okay, but that's what I was trying to determine, guess, based upon your observation. So if it's 20 states that are now adopted the basic customer method, there'd still be 30 states that have not.
Or are somewhere kind of in the middle, or
between.
haven't really like established haven't really established kind of a line in the sand as to how they want to see things done.
Sure, thank you.
Okay, this brings us to the end of the day. So we're going to be in recess until tomorrow morning at 10 o'clock, and we will adjourn at 10 o'clock with questions on commission questions. Okay. Thank you. We'll go off the record now.